Aloha, we are live from the Hawaii Tax Institute. We were very fortunate to have a return interviewee from last year, Vivian Thoreen, who is a partner and the head litigation practice leader for Holland & Knight, based out of their Los Angeles office. So Vivian, part of your talk is you're talking about when to engage a healthcare professional to really assess capacity, undue influence, and coercion.
There are two different ways in which a healthcare professional would be engaged. One is at the time that the estate plan is being prepared and before the client signs it, but it's also retrospectively after the client has passed away when to engage a professional. If an attorney has concerns about their client's capacity, regardless of the underlying reason for the question of capacity, then the attorney should consider hiring a health professional. What's really important, though, about hiring the healthcare professional, in my opinion, is it's important to know exactly why you're retaining them. Is it for capacity-related reasons? Is it for undue influence reasons? Or is it both? Because sometimes the healthcare professional is retained to assess capacity, but later the issue becomes not capacity, but whether or not and to what extent mom was unduly influenced. And yet it's not going to be reflected in their examination after the fact. Some other factors that I would look to are make sure that the attorney is the person retaining the healthcare professional. There are privilege and work product related issues that would be important to preserve for this process, so that if and when they call someone like me, your file is intact and there are protections made to preserve the integrity of the communications and the report that's generated.
Are there any structures or planning that one could do ahead of time to mitigate the possibility or to prevent the possibility of pending litigation?
The short answer is there's nothing you can do. If someone wants to litigate, they will litigate. I've seen in my practice, however, that there are some clever estate planning strategies that some attorneys have used, and they include things like what I call serial amendments. So that if a parent, for example, is contemplating major changes to their estate plan, rather than do it in one fell swoop, do it slowly over time, over a number of documents, and transition it a little bit more slowly. Because at the end of the day, if there's a challenge and the child wants to get back to a point in time, they must overturn not just one, but perhaps 3 or 5 or 10 amendments. We talked about medical exams. That would be really good to have if litigation is anticipated, or in terms of preventing it, because the medical professional is acting in real time with the client, and they're in the best position to have historical information about the client's prior estate planning wishes, their medical condition, possibly relationships with other family members.
Do they typically videotape those interviews?
I firmly believe, from a preventative perspective, that unless an attorney is well versed in filming and has their procedures down to a T, it should not be done. As a litigant, as an advocate for a client, I would love a videotaped execution. I would love it, because like this interview, there are multiple takes, there are prior versions, there are edits, and you would be entitled to all of that information.
Can you give us an example of some cases that you worked on with either bad planning that led to litigation or planning that prevented litigation?
So an example of a plan that was done very poorly that led to litigation was the estate planning attorney relied too heavily on the child facilitating the communications, and I believe spent insufficient time with his client confirming independently that these proposed changes are in fact what his client wanted. And it sounds so basic, and it is. You have to confirm with your own client that this is what he or she wants. That's your job. An example of a good estate plan would be where the estate planning attorney followed all the rules and said, look, I would like to hear from you, that's great, but I really need to make sure that this plan is reflective of my client's intentions. And if there's a medical exam involved, for example, the timing of the medical exam is key. You want to have the medical exam as close in time to the moment before the client is going to sign their estate plan. How relevant is it going to be if there's a medical evaluation 6 months before the client signs the estate plan? It's not.